Bismillahirrahmanirrahim. Mr. President, distinguished members of the court. It is an honor for Malaysia to appear again before the court in these advisory proceedings. Yet it is a somber honor. We come not merely as a member of the United Nations, but as a voice echoing the pain of a people whose rights, homes and future are being dismantled before the eyes of the world. The question before the court is a grave one. What are the obligations of an occupying power and of a member of the United Nations that continues without regard for international law or human decency to obstruct, undermine and dismantle the very systems built to preserve human life and dignity in the occupied Palestinian territory? A little over a year ago, Malaysia was addressing the court on the policies and practices of Israel in the OPT. Unfortunately, the situation in the OPT has deteriorated even further since that day in February 2024. What was then widespread devastation has now evolved into openly declared, brutally enforced and tragically ignored outright displacement and destruction. In the last few weeks, we have witnessed not only a renewed offensive against the Palestinian population in the Gaza Strip and the West Bank, but also statements by senior Israel officials that leave no doubt Israel's intention is to bring about the ultimate denial of the Palestinian people's right to self-determination through their eventual displacement and elimination. Just in these last few weeks, Israel Defense Minister Katz has on 2 occasions admitted openly that the target of Israel operation is in the civilian population of Gaza.
I'm sorry to interrupt you, but could you please speak more slowly?
Yes,
to
of course.
Interpretation.
I will try, Mr. President. On 19 March, Katz addressed a final warning to the residents of Gaza. The Air Force strikes against Hamas, he said, were just the first step. It will become much more difficult, and you, the residents of Gaza, will pay the full price. Katz continued, return the hostages and remove Hamas, and other options will open for you, including leaving for other places in the world for those who want to. The alternative is absolute destruction. Again on 2nd April, Katz posted on Twitter X, the goal of Operation Strength and Sword is first and foremost to increase pressure for the release of all hostages. But the goal is not to increase the pressure just on Hamas, Mr. President. According to Minister Katz, the goal is to increase the pressure also on the population in Gaza. Katz finished his post by calling on the residents of Gaza to act now to remove Hamas and return all the hostages. This is the only way to end the war. Threatening the civilian population of Gaza with destruction unless they remove Hamas and return the hostages, an objective that even Israel, with all its military might, has not even come close to achieving in over a year and a half of merciless killing and maiming. This demonstrates Israel's intention is in no uncertain terms. Israel's allies themselves confirmed this before Israel's violation of ceasefire, when they stated in February that Gaza is hell, a pure demolition site, and not a place for people to be living. According to such Israel allies, Palestinians have experienced nothing but death and destruction, and their return to Gaza is a guarantee that they are going to end up dying. What more is there to be said as to the objective that Israel is pursuing, Mr. President? Even before it shattered the ceasefire and renewed its offensive on 18 March, Israel imposed a total blockage on the humanitarian relief destined for Gaza, closing all border crossings and completely cutting off the electricity supply into the Strip. The stated aim of these unlawful and inhuman measures was to exert pressure on Hamas to accept changes to the already agreed upon ceasefire. This demonstrates Israel's control as an occupying power over life and death in the Strip. It also brings the subject matter of the request for an advisory opinion currently before your court into sharp relief. These Israel measures have been taken following Israel's passage of legislation purporting to ban the operation of the United Nations Relief and Works Agency for Palestinian refugees in Near East, both in Israel and in the occupied Palestinian territory. Malaysia is saddened, but unfortunately not surprised. To add all, this has been happening is the face of provisional measure orders handed down by the court in case brought by South Africa against Israel, and in the face of the advisory opinion of 19 July 2024. It is typical of Israel to ignore its international obligations, and the decision of this court, the principal judicial organ of the United Nations. And yet, we are here to try and to get some clarity on the obligations of Israel as an occupying power and as a member of the United Nations as this relate to the OPT. The authoritative statements of these obligations by the court will greatly assist the General Assembly in its effort to bring to an end, in accordance with the court's advisory opinion, as mentioned, Israel's unlawful occupation of the OPT. Malaysia's submission today is straightforward. It builds upon its submission and the court's advisory opinion of 2024. It can be essentially distilled into the following arguments. 1. The obligations of Israel as an occupying power, as they have been detailed in the Malaysian's written statement, as they will be summarized in our presentation today, are established to accord protection to a people under foreign occupation. Second, the obligation of Israel as a member of the United Nations are established in pursuit of the organization's purpose to develop friendly relations among nations based on respect for the principle of equal rights and self-determination. Third, the recent policies and practices of Israel, especially with respect to UNRWA, do not only constitute violations of its obligation as an occupying power and as a member of the United Nations. Rather, taken together, they are also in serious breach of each of the four aspects of the right to self-determination of the Palestinian people. As these were detailed by the court in its advisory opinion of 19 July 2024, in this presentation, we will first deal briefly with the court's jurisdiction and its discretion to respond to the request of the General Assembly. In the third part of our presentation, we will summarize what Malaysia submits are the obligations of Israel as the occupying power and a member of the United Nations in relation to the OPT, especially with respect to the operation of UNRWA. In the final part of our presentation, we will demonstrate how the policies and practices of Israel in this respect not only violate the obligations that we have summarized, but constitute a grave breach of the right of the Palestinian people to self-determination. Mr. President, members of the court, allow me to be brief when it comes to your jurisdiction and the exercise of your discretion in the present request for an advisory opinion. With respect to jurisdiction, it appears obvious to Malaysia that the General Assembly is competent to submit this request, and that the request for the court to give its opinion on a legal question. In particular, the question is for the court to set out the obligations of a state under international law in a particular context. It is thus a question framed in terms of law and raising problems of international law, thereby being, by its very nature, susceptible to a reply based on law. As regards the court's discretion, it is Malaysia's submission that there are no compelling reasons for the court to decline the exercise of its jurisdiction in the instance. There are no such reasons anymore than there were in the Wall opinion, or indeed in the opinion of 19 July 2024, of which this request can be seen as an extension. What led to this request is indeed the adoption of Israel's policy and practices in the OPT, as this relate to the UN, other international organizations, and the third state. What is more, the purportedly compelling reasons invoked by some states in their written statements, such as the Eastern Karelia Principle, the alleged insufficiency of factual information before the court, and the complexity of the situation in the Middle East, have been pleaded before this court time and time again in similar circumstances and have been consistently rejected. Malaysia respectfully submit that there is no reason for the court to diverge from this constant jurisprudence. Mr. President, members of the court has already found that the OPT constitutes a single territorial unit, and that Israel has obligation as an occupying power of that whole territorial unit, obligations which are commensurate with the degree of its effective control over it. This effective control is today complete, including over the Gaza Strip, as our introductory references to Israel's total cutting off humanitarian aid and electricity in Gaza have demonstrated. As the occupying power over the whole of OPT, Israel is under a matrix of obligation which emanate from international humanitarian law and international human rights law. The latter remains applicable even during armed conflict. As the court has consistently found, Malaysia will not go through these obligations here. We respectfully refer the court to Malaysia's written statement which set out these obligations in some detail. Malaysia will, however, provide a general structure of the matrix of obligation incumbent upon Israel as the occupying power. The matrix is construed by relevant provisions, which is the Hague Regulation of 1907, the Fourth Geneva Convention of 1949, and the First Additional Protocol of 1977. These reflect not just international customary law, but intransgressible principles of international customary law Malaysia submits. They are supplemented by obligations under international human rights law. Taken together, these obligations establish that Israel, as the occupying power, must administer the OPT for the benefit of the local population. Israel is under a set of positive obligations to ensure that the civilian population in the OPT is adequately provided with food, water, shelter, clothing, fuel, energy, and generally all the necessities of life, along with educational and health services. In parallel, Israel is under a set of negative obligations not to hinder or interfere with the operation of health and education services or with the operations of humanitarian organizations in the OPT. If the civilian population is inadequately supplied, which in our case there is no question that it is, then the matrix of obligation incumbent upon Israel requires it to agree to and to facilitate relief schemes, including by impartial humanitarian organization to facilitate distribution of relief consignments, and to guarantee the protection of such relief and the relevant humanitarian personnel engaged in its transport and distribution. It is Malaysia's submission, Mr. President, that Israel is in clear breach of this whole matrix of obligation of an occupying power. Israel has not only kept the OPT chronically undersupplied, adding insult to injury, it has been consistently draining it of its resources, such as they are. Or it has been wantonly destroying them, along with facilities dedicated to education and health. Most recently, Israel has legislated to ban the operation of UNRWA in the OPT, essentially stopping the only humanitarian organization that has assumed comprehensive responsibility for the provision of the civilian population. And he has now completely blocked any humanitarian aid and electricity into Gaza as well, as we have already reported. But Malaysia has one further submission to make this connection, Mr. President. That is, UNRWA functions as a humanitarian substitute of the protecting power under international humanitarian law. As Additional Protocol 1 reminds us, the system of protecting power is compulsory. It's not merely an option. In the absence of protecting power or an official substitute, Israel as the occupying power is under an unconditional obligation to accept the offer of a humanitarian organization to function as a humanitarian substitute. It is the United Nations acting to UNRWA that has been operating as a humanitarian substitute of protecting power in the OPT since inception. And certainly since the exchange of letters of 14 July 1967 with respect to Israel. Israel had no latitude to refuse the offer of UNRWA to undertake the humanitarian functions provided for in the Fourth General Convention with respect to the OPT, Fourth Geneva Convention with respect to the OPT. And Israel cannot validly withdraw its consent with respect to UNRWA's humanitarian operations. And its purpose to do through its law to cease UNRWA operations unless it requests or accepts the offer of another humanitarian organization within the 2-month time limit understood to be prescribed by the Fourth Geneva Convention for that purpose. Mr. President, members of the court, Israel has been a member of the United Nations since May 1949. It bears a set of obligations under the UN Charter, as well as under the 1946 Convention on UN Privileges and Immunities. A number of these obligations relate to the President's activities of UN, including UNRWA as a subsidiary organ of the General Assembly, in and in relations to the OPT. With your permission, we will provide an overview of the content of this obligation, which, as with this obligation of Israel as an occupying power, have been set out in some detail with Malaysia's written statement. As a member of UN, Israel is under an obligation to accord the organization with self-evidently can only operate through its organs, the necessary legal capacity in its territory, so as to enable the exercise of UN functions and the achievement of UN purpose. It is also under an obligation to respect the organization and its officials' privileges and immunities. And these are set out in the 1946 Convention. In particular, the obligation covers the premises, property, assets, and archives of UN, and the protection granted is absolute. Further, any alleged violation on the part of UN of its own obligations cannot lead to a loss or withdrawal of such protection, but only to the invocation of the responsibility of the UN in accordance with international law. UN officials, including all UNRWA staff, except locally recruited staff that is assigned to hourly rates, also enjoy the protection of Article 105 of the Charter and of the relevant provisions of the 1946 Convention. Finally, the combination of the provisions of Article 1, Para 3, Article 2, Paragraph 2, Article 2, Paragraph 5, 55, and 56 of the Charter clearly establishes an obligation for Israel to cooperate with the organization in good faith in striving for economic, social, health, cultural, education, and humanitarian development. Israel must cooperate with the UN to ultimately achieve respect for human rights, as well as equal rights and self-determination of people. It is clear to Malaysia, Mr. President, that Israel's adoption and implementation of the law to cease UNRWA operations and of the law to cease UNRWA operations in the territory of the State of Israel put it in direct breach of this obligation. These pieces of legislation essentially aim to deprive UNRWA and through it the United Nations of its legal capacity in territory that Israel controls. They prohibit the operations of UN officers in breach of privileges and immunities of the United Nations. They have led to the non-renewal of work visa for UNRWA international staff that were forced to leave the OPT in January 2025, and to threat of criminal proceedings against UN officials in breach of their privileges and immunities. And ultimately, they egregiously violate Israel's obligation to cooperate with the organization in good faith. This is on top of all various other policies, practices, and conduct of Israel in breach of this obligation, ranging from the destruction of UN property and premises, including UNRWA schools, health clinics, and vehicles, to measures taken against the UN Secretary General, to the willful and persistent disregard of the decision of this court. In concluding to this section of Malaysia's presentation, Mr. President, we would like to make one more point. It is Malaysia's submission that Israel cannot validly terminate the 1967 exchange of letters unilaterally. This is because, under its own terms, the agreement between Israel and the UN remains in force until replaced or cancelled. Replacement or cancellation must take place by mutual consent. As this court has found in its advisory opinion on the agreement between WHO and Egypt, any modification to or termination of such an agreement needs to be negotiated in good faith between parties. Mr. President, members of the court, the obligations we have set out are ultimately meant to support and entrench the right to self-determination. The rules of international humanitarian law do so by according protection to a people under foreign occupation. The rules of UN Charter and the 1946 Convention do so by according protection to the United Nations in its pursuit of its purpose of developing friendly relations among nations based on respect for the principle of self-determination. Ultimately, Mr. President, Malaysia's argument boils down to this. The recent policies and practices of Israel towards the United Nations, and in particular UNRWA, taken together, constitute violations not only of the obligation we have sketched out already, but also of each of the four aspects of the right to self-determination that the court identified in its advisory opinion of 19 July 2024. First, with respect to the right of territorial integrity as a corollary of the right to self-determination, The laws purporting to cease the operations of UNRWA, along with the administrative measure pursued against UNRWA premises, are a further step in the entrenchment of the ongoing annexation of the occupied Palestinian territory. The attempt by Israel Land Authority to seize UNRWA premises reportedly in order to construct 1,440 housing units is typical of Israel, conduct found to constitute annexation by the court in its advisory opinion of 19 July 2024. Second, with respect to the right of the people to its integrity, the cessation of the operation of UNRWA, which provides education through a large network of schools, primary health care through a large network of health clinics, and vital supplies through an extensive distribution network, is calculated to force the departure of Palestinian populations from the affected areas, which essentially include all the occupied Palestinian territory. This is evident now more than ever, and especially in Gaza. Third, with respect to the right of permanent sovereignty over natural resources, the expulsion of UNRWA is calculated to cause a humanitarian catastrophe. Given that Israel has been exploiting the natural resources of the OPT for its own benefit and for the benefit of illegal settlements for decades, the natural resources of the West Bank have been depleted, and the Gaza Strip has been reduced to rubble. Removing the lifeline of UNRWA will signal the ultimate collapse of the OPT's ability to sustain itself. The Palestinian Authority has already made it clear that it does not have the financial resources or capacity to compensate for the loss of the UNRWA services. Fourth, with respect to the right of the people freely to determine its political status and to pursue its economic, social, and cultural development, the expulsion of UNRWA with the concomitant cessation of operation of its schools, its clinics, humanitarian relief, development assistance, microfinance and micro-enterprise schemes, and other programs will lead to further deterioration of the Palestinian people's ability to enjoy even basic human rights, to educate themselves, and to hope to build a future in their own sovereign state. States undertake obligation not as a rhetorical gesture, but with a view to achieving certain ends. Malaysia submits that the obligation assumed by occupying powers and by members of the UN have as their ultimate end the protection of people from extinction and the safeguard of their right to self-determination. Mr. President, this concludes Malaysia's submission today. Malaysia thanks the court for its kind attention. We also thank the Secretariat and the interpreters for their diligent work. And I do apologize if I was running very fast. Before I end, and before I sit down, Mr. President, let me end with a quote from Plato: "The worst form of injustice is pretended justice." Thank you so much.
Mr. President, members of the court, Malaysia stands here not merely to interpret international law, but to amplify the voices of a people whose lives are suspended in injustice. We have shown that Israel's actions in the occupied Palestinian territory, its policies of displacement, destruction, and deliberate targeting of civilians amount to clear violations of its obligations as an occupying power and as a member of the United Nations. We have highlighted how Israel's systematic undermining of UNRWA, its complete blockade of Gaza, and its coercive language against the civilian population are not isolated acts. They form part of a wider, sustained strategy that strikes at the very heart of the Palestinian people's right to self-determination. This court has the power and the responsibility to reaffirm the rule of law. We trust that your authoritative opinion will provide clarity not only for the General Assembly, but for the global conscience, affirming that impunity must not be the legacy of occupation. Let this be a moment where justice is not delayed again. Let this opinion mark a turning point, one where international law reclaims its rightful place in the defense of humanity. We thank the court for its attention.